Hey, you guys, welcome back. This is Nina. Like, share, and subscribe. Thank you for everybody that has been coming to my channel. Please like this video, share this video, and hit that subscription and notification bell so you know when I drop my next video. Now, I'm going to get into this Drew Drechsel ANW situation. For all of my long-time day one subscribers, you guys know I've been following this case now for 2 years, and I've been trying to give you as many updates as possible. As of right now, if you guys can believe it or not, this case is still in continuance. He did go to court recently. However, again, it was continued. Now, because of this, I chose not to make an update video, but because so many of my subscribers have been coming and asking me to do some sort of video just to let them know what is going on, I'm going to let you guys know right now. This case has been continued. Nothing has been settled. There has been no new evidence put up front. No other women came forward. Now, I do want to go over a very important topic because I was very curious about this. I wanted to give you guys some information on legal reasons why his case may be continued. And this is a really good article. This article is from a lawyer's website that explains continuances in criminal cases. So I am about to read this, and this is going to explain some of the various reasons why his case is being continued. Now, here we go. Lawyers and clients frequently want continuances to prepare their cases, but they don't always get them. A continuance is a grant of additional preparation time before or during a trial. Either the prosecution or the defense can request a continuance, and sometimes even the court can order a continuance on its own accord. Now, from what I do know from looking at all of the information concerning Drew Drechel's court issues, a lot of the continuances has been granted from his side, the defense. There has been a couple on the prosecutor's side. However, more has been on the defense, and there were continuances granted directly from the court at the peak of COVID right after he was arrested. You guys remember back in like 2020, 21, when everything was pretty much closed. So yeah, the court has also done continuances for this trial. Also, here are some primary reasons why a case gets continued. Lawyers typically seek continuances because they want more time to prepare for trial. Here are the common reasons. Insufficient time to prepare in general. Both the prosecution and defense are entitled to a reasonable time to prepare for trial. Exactly what constitutes a reasonable time is open to interpretation and depends on the circumstances and complexity of a particular case. In general, each side must be given sufficient time to A. Review the evidence, B. Investigate the facts, C. Consult with the witnesses, D. Negotiate a plea agreement if one is possible, and in the case of the defense, hold lawyer-client meetings. Now, we do know lately his lawyers and the prosecutors have been trying to negotiate a plea agreement. However, I could not get any information on what is the average time it takes to reach or try to reach a reasonable plea agreement for both sides. Neither side may excessively delay the trial for its own advantage, especially the prosecution. An unreasonable delay can violate the defendant's Sixth Amendment right to a speedy trial. Attorneys often request continuances because their work on other cases has prevented them from devoting the necessary time to the case at hand. Courts usually allow some leeway in these situations, especially for court-appointed defense attorneys. As far as I'm aware, this is not a court-appointed defense attorney. Drew Drechsel is actually paying for his lawyer, from what information I did gather. Time for defense. While both the prosecution and defense are entitled to a reasonable time to prepare, time shortages most often affect the latter. A lack of adequate time that renders an attorney ineffective in representing the client violates the Sixth Amendment right to counsel. On the other hand, if defense counsel has had ample time to prepare and no surprising event justifies a grant of additional time, a judge won't hesitate to deny a continuance request. Courts will also deny continuance requests if a defendant or defense attorney calls the need for more time through negligence or delay, also known as laches. And I guess laches is the legal terminology for time delay. Changes to the indictment or information. The addition of new facts or crimes to indictment or information, the document that charges a defendant with crimes, will typically require additional time to prepare a defense. For example, the prosecution changing the alleged date of a crime might justify a continuance to allow the defendant to prepare an alibi for the date in question. However, a continuance due to a change in a charging document is warranted only if the change, known as a variance, compromises the defense's case. If the prosecutor makes changes merely to correct technical defects, and those defects don't alter the case in any meaningful way, then a judge probably won't grant a continuance. Replacing counsel. The Sixth Amendment guarantees criminal defendants the right to counsel, but that right has limitations. Defendants have the right to counsel of their choosing, within reason. When a defendant wants to change their defense attorney for another, the court must consider several factors before granting a continuance to allow the new lawyer to prepare. A judge may not arbitrarily insist that the case move forward when it's clear that a continuance is needed for a new lawyer. A judge won't grant a continuance if the defendant has unreasonably delayed in getting a new attorney, the defendant has another attorney who is prepared for trial, the continuance won't help the new attorney adequately represent the defendant, or the defendant fails to explain why a new lawyer is necessary. Again, from the information I have, Drew Drechsel is using the same attorneys and has not changed counsel. Surprise witnesses or evidence. New events or information previously unknown to the defense, for example, a new witness revealed the day before trial, or new physical evidence supporting the prosecution's case, will likely warrant a continuance. Similarly, in some cases, the absence of a witness that the defendant expected to be present may necessitate additional time so that the defendant can try to get witnesses to court. A judge may deny a continuance when the new evidence is reasonably related to evidence the defendant already knows about. The defendant has enough time without the continuance to prepare for the new evidence. The defendant wasn't diligent in anticipating the evidence. For example, defense counsel failed to read forensic reports turned over by prosecution and was surprised when the prosecution's forensic expert team testified to test results contained in the reports, or the defendant fails to properly inform the court of the surprise evidence or witness. Surprise testimony. It is not uncommon for the prosecution's witness to say something at trial that they either never said before, for example, when interviewed by the police, or that contradicts statements they've made in the past. When this happens, continuances are proper if the defense can show that the defendant didn't anticipate or can't be expected to have anticipated the testimony, wants to present the testimony or evidence to counter the surprise testimony, and can present the contradictory evidence in a reasonable period of time. As always, the defendant's negligence contributed to the surprise. The judge can't reject the continuance request. The judge can reject the continuance request. Additionally, a court usually won't grant a continuance where surprise testimony comes from one of the defendant's own witnesses. How courts view continuance requests. Because continuances delay the resolution of a case, judges typically frown upon them. It's usually only when the defendant's rights might be otherwise violated that a court will grant a continuance request. Absent a law or constitutional right to the contrary, judges have broad discretion to determine whether to issue a continuance. Diligence. Perhaps the most important consideration for a judge is whether the party requesting the continuance has been diligent. In other words, whether the party put in sufficient effort. Parties must be active in reviewing evidence, interviewing witnesses, issuing subpoenas, and testing forensic evidence. Additionally, defendants must be conscious in obtaining counsel and alerting the court to any problems with current counsel. Exercising diligence means the party has done everything reasonable, not everything possible. Like most issues relating to continuances, the definition of diligence depends upon the facts and circumstances of the particular case. Now, that gives you guys the information on the continuances. I hope that this brings some clarity on some of the issues that may have arisen with 2 years of continuances that this case has gotten. I hope that this, again, gives you guys some reasonability in how the judge is looking at these continuances. However, like I said, 2 years is a long time, and I really think that this either needs to be plead out at this point, which I believe this is what it's leading to, and we can move on with sentencing. As of right now, Drew Drechsel is still locked up in federal custody. He has not been granted bail. He has been in custody of federal courts since August of 2020. That is your Drew Drechsel update, you guys. Please like, share, and subscribe. This has just been a mess of a case. I just hope that there can be some conclusion to this at this point. I do believe that the next court date, as soon as it come up, I think that will be getting close to the end game, because like I said, I think a lot of time has been given, and I think it has been reasonable. Like, share, subscribe. Till next time, enjoy your day. Bye, guys.